I'm Deseriee Kennedy. I'm a professor here at Touro, and I'll be moderating this panel on law and society. I am excited to hear these presentations on how disability reshapes concepts of justice, rights, and belonging across legal, professional, and social contexts. Today we'll be hearing from Chasity Bailey, who is a licensed attorney in Virginia living with cerebral palsy and low vision. She has found purpose in advocating for inclusion within the legal space and beyond. We'll also be hearing from Lucia and Silecchia, who will be speaking to us about the hidden treasure of spiritual care. She is a teacher at Catholic University's Columbus School of Law, where she's taught since 1991. And she teaches and writes on environmental law and ethics, property, elder law, Catholic social thought, legal education, and law and literature. Finally, we'll be hearing from Alon H. Sugarman, who is a litigation associate at Gibson, Dunn, and Crutcher. He practices a wide range of litigation from securities class actions to bankruptcy and contract disputes. He's also a disabled lawyer, a childhood cancer survivor, and an amputee. You can find more about each of our panelists in the program. Before we begin our panel, I'd like to read the CLE code. It is EJP627. And now I'd like to turn it over to our first panelist. Ms. Bailey?
Thank you. As Deseriee said, my name is Chasity Bailey. I'm an associate counsel. I primarily work in the corporate transaction space. Sorry. My name is Chasity Bailey. I'm an associate counsel. I primarily work in the corporate transaction space at Dominion Energy. I was born in 1987 with cerebral palsy. My birth mother immediately put me up for adoption. It must have been God's will because my real parents welcomed me into their arms and our home. It wasn't an easy transition, however. You remember how that gentleman talked about institutionalization for people with disabilities? Well, the state of West Virginia argued in the courtroom about whether I should be institutionalized or allowed to be raised by my wonderful family. We did win, but not without a big fight. From then on, my parents had to advocate for me from court to the classroom to the playground and beyond. I remember what Owen said and his family discussed about his childhood. It was very similar. At school, some teachers didn't want me to play with the other kids at recess because they were afraid I would get hurt. I was very small. I don't think this is going forward like it should. I was very small, basically. This was kindergarten. I was a little bit bigger than what you see here with my dad. So when the 6th grade girl came over and invited me to play, I was very ecstatic. Of course, this was awesome, and I was 5. And an older person wanted to play with me. So I went and said, awesome, yay, let's go. So I remember reaching up for her to lift me up because her objective was to put me on top of a pyramid because, again, I'm small, I could fit. By that time, before she could even lift me up, I heard a teacher just scream in panic and run across the playground. No, 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 put her down, stop, go, don't do that. Just completely panicked. Of course, I was distraught. I was upset. I went home and told my dad what happened, and I remember him marching down to the school saying, let her play. If she falls, she'll get back up. I did fall. I still fall, and I still get back up. So what's very important to remember is I was born in 1987. I'm 38, about ready to be 39. So the ADA was passed in 1990 when I was 3. By that time, I was already building my own bridges into the world. I like to do a lot of imaginative play. I loved reading. I still do. A lot of solitary activities because due to the way I was born and the circumstances surrounding that, My immune system was very, very low, so the fear was if I was to get around another child who was sick with a cold or something that they could easily fight off, I wouldn't be able to. So I remember really making up this very creative world in my own head. And I think that was basically my saving grace, because instead of seeing problems, I saw solutions. So fast forward a little bit, I went to law school at William and Mary. When I came there, I was completely expecting the hard test, the late night study sessions, all of that. I was prepared. I excelled in academia. I love school. I always have. That was no problem. But what I failed to realize, however, is the legal stereotype of the lawyer is not only prevalent in Hollywood, but also in society. So basically, this is a gentleman that I think represents what society thinks a lawyer should be. As you can see from my screen, society's viewpoint is that an attorney is a man, usually, who lives in red lines and routinely makes his home in boardrooms, artfully crafting the million-dollar deal while wearing an air of confidence and a broad smile. And this isn't anyone I know, this is just a random person from Google, so please don't think I'm picking on my colleagues. I'm not. So basically, these people, when you do see them in media and in real life, they're always predictably mobile, they're always boisterous, and very overconfident. Well, as you can see from me, I don't fit the stereotype. So this was a problem when I was looking for work. It shouldn't be a problem, however, because when we anchor our legal system to rigid ideas, we are not practicing the law, we are practicing exclusion. The most brilliant minds don't come from a traditional background, they actually forge bridges that other people will follow. So after law school, there was no job offers, even though I went on tons of interviews. I can't explain the nature of those interviews. It was really surreal. I would walk in there, and I can't mask my disability. I know there has been a lot of talk about masking. I can't mask mine, even if I wanted to. Not that anyone should have to, but I physically can't. So when I'd walk into the room, people automatically knew something was up, right? But we're talking to attorneys. They knew not to ask the question, but they had their own ideas of what was going on, and it didn't really help me any. So to get my first job, I had to network. By networking with everyone that I possibly could, I finally met a fellow student at William & Mary that introduced me to someone that she knew at the company I worked for, Dominion Energy, who was able to get me in, not in the law field, but in a role as public policy. And from then, I transferred to regulatory compliance, and now I'm finally in corporate transactions practicing the law, but it was a long road to get here and very non-traditional. Most people out of law school, they go into a firm for 5 years, and then they transfer in-house. I didn't get that opportunity, so I had to find a very creative way to practice the law. My company, before they did this for me, the associate counsel role, that had never been done. They always took in people from firms that had a level of expertise, but they wanted me to try that role to see if others could potentially do it too. So I'm finally practicing law. My point in all this is not to get into what I've accomplished or what I've done. I'm also on the William & Mary Alumni Board. Children's Home Society of Virginia, those are my two boards I'm on. I work as an attorney, but that's not the point of this presentation. The point is to say that unfortunately, people with disabilities have to take very non-traditional and creative paths to get to the professional point in their life that they want to be, which is very unfair. But hopefully, by raising more awareness that this is happening, we can potentially do something to make things better for future generations. So my final point is, if the law is truly to be the foundation of society, it must be strong enough to reflect society, not just those who fit the stereotypical blueprint. My idea is to widen the bridge so everyone who wants to practice law and has the ability to do it can find a way there easily, not to exclude the stereotypical lawyer, but to let other people who want to practice the profession be able to, and be able to do that more readily. Any questions?
Professor Silecchia.
Well, first, it's a great pleasure to be here, and thank you to Touro and especially to Professor Levine for organizing this important conversation. In a panel on cultural and social perspectives, I think for many people, an enormously important part of their culture and an important part of society is their faith. And so I'd like to talk for a little bit about a topic that I call the hidden treasure of spiritual care, a forgotten right of persons with disabilities. And I think part of my interest in it is that this right to the access to spiritual care and to religious free exercise, I think is ignored and neglected by advocates for persons with disabilities and advocates for religious liberty. And as I take a look at the attention that is paid to the rights of persons with disabilities and litigation on behalf of those arguing for greater freedom in religious exercise, it seems to me that these two lines of advocacy at times are not connected. And so what I'd like to do is discuss what I believe are the limits that law has in defending the rights to spiritual care and religious exercise for persons with disabilities, and then discuss that in light of those legal limitations, there's an enormous obligation on religious communities to do that outreach that I think the law might not be doing. So at the outset, I acknowledge that there's growing recognition of the rights of persons with disabilities who live within institutions of various kinds. But this is extremely limited because most people with disabilities live independently or with their families in communities. And so what I'd like to do is explore three broad legal frameworks: the Convention on the Rights of Persons with Disabilities, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Acts, and the Americans with Disability Act. And for each, I want to point out the ways in which they fall short in protecting the rights of persons with disabilities to robust freedom of religion and meaningful spiritual care, and then make some recommendations on how religious communities themselves might help fill in those gaps so that the law more fully remembers this forgotten right. So I'd like to begin with the 2006 Convention on the Rights of Persons with Disabilities, arguably the most expansive declaration of the rights of those living with disabilities. And throughout, the CRPD casts a broad net in articulating rights, and the breadth of these rights has been largely and favorably commented on. Many of these rights include those basic fundamental first-generation human rights that are at the core of human dignity. And the CRPD also claims as rights many things that would not be traditionally considered core elements of a traditional framework of right. For example, the CRPD talks about rights to such things as free access to museums, sports, television, and cinema. These are all specifically mentioned in the CRPD as necessary to advance the full human dignity of persons with disabilities. So in light of this broad scope, it's unclear to me why freedom of religion, a classic first-generation human right, is ignored in the CRPD. Indeed, although ranking human rights as problematic, religious freedom has long been considered one of the most basic rights. Yet, perhaps, things such as the right to autonomy and independence and the right to freedom of expression and opinion, although those are mentioned in the CRPD and may be broadly interpreted to include religious liberty, these are not mentioned explicitly at all in the pages of the CRPD. And yet, for so many, the right to the freedom of religious exercise, both in public liturgy, private worship, communal prayer, and the living out of their religious commitments, is a core aspect of so many people's very identity and existence. This is no less true for persons with disabilities than it is for anyone else. And indeed, for many people, it is religious communities that are a primary source of community, strength, and solace. Nowhere in the CRPD, however, are basic rights to pursue religious freedom ever addressed. The CRPD does speak generally about fostering an attitude of respect and to foster respect for the rights and dignity of persons with disabilities, and yet, disappointingly, the need to protect religious exercise is not mentioned in this landmark document. In a startling contrast, the Convention on the Rights of the Child mentions religious rights of children, and to me this is a troubling inconsistency. Second, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act of 2017 also pays scant attention to the religious freedom and spiritual care needs of persons living under guardianships. And while certainly not all persons with disabilities are impacted by guardianship laws, adults subject to guardianships are almost always those with a disability of some kind. Because the control that a guardian may have over all aspects of a protected person's life is so extensive, it is important that the UGPPA speak directly to this need for religious freedom and spiritual care. Yet here again, it is disappointingly lacking. In very general terms, the statute, and I'm speaking only of the uniform statute, recognizing many state variations, says that guardians for an adult shall promote the self-determination of the adult, and that they should, to the extent reasonably feasible, identify the values and preferences of the adult, and involve the adult in decisions affecting the adult, including decisions about care, dwelling, activity, and social interactions, and make reasonable efforts to identify and facilitate supportive relationships and services. It is certainly true that things such as values, activities, or social interactions, and supportive relationships and services can easily be construed to include relationships and activities of a religious or spiritual nature. But if this is the case, why not say so explicitly? Later, in listing the 3 factors that a guardian is to consider in determining the best interests of the adult, the UGPPA lists only 3 things: information from professionals and persons that demonstrate sufficient interest in the welfare of the adult, other information the guardian believes the adult would have considered if the adult was able to act, and other factors a reasonable person in the position of the adult would consider. Here again, a broad reading of these 3 factors could easily include religious considerations. Yet, given the centrality of religion in many people's lives and the way in which religious beliefs may play a significant role in decision-making, the UGPPA should have listed it explicitly as a factor that a guardian should consider. Further on, the UGPPA continues to discuss the role of the guardian in facilitating social relationships. It speaks boldly of the necessity for guardians not to restrict the ability of the adult to communicate, visit, or interact with others to participate in social activities. In my view, this should also make explicit reference to members of the clergy and lay members of religious activities, and should mention spiritual and religious activities in addition to merely social activities. Particularly if these issues are not of personal interest to the guardian, their importance may not be fully appreciated. More troubling, in the section that requires guardians to develop a plan for an adult being cared for, none of the required elements of the plan address a plan for full participation in religious activities. A guardian is required to report on the mental, physical, and social condition of the adult, but it would be helpful if spiritual well-being were also recognized as important. This would require guardians, to the extent possible, to ascertain what the person in their care desired with respect to spiritual care. And finally, the Americans with Disability Act does little to establish the importance of religion to persons with disabilities, and in fact provides an interesting point of reflection as to when there may be a conflict between protections for religious free exercises and the rights of persons with disabilities. The ADA begins with a broad statement that disabilities in no way shall in no way diminish a person's right to fully participate in all aspects of society, including employment, housing, public accommodations, education, transportation, communication, recreation, institutionalization, health services, voting, and access to public service. However, primary subchapters of the ADA contain specific provisions exempting from its mandates religious organizations or entities controlled by religious organizations, including places of worship. Given the significant gaps in the law, ultimately, it may be religious entities themselves who must take the lead in protecting the rights of persons with disabilities to fully participate in the religious practices they hold dear. This is an enormous responsibility for the entire community, but one that is necessary to ensure that all are included in faith communities and truly belong in the full sense of that word, as members serving, being served, caring, being cared for, and honoring the God that draws them to their spiritual home. And so, in the time I have left, very quickly and briefly, 7 suggestions for faith communities to meet this obligation. First, faith communities may have a unique role in developing a theological understanding of disability, and in particularly in the theological underpinnings of the dignity of all human persons. Second, as we know, religious communities play a role in the public square as advocates, and I'd encourage religious communities to focus their attention on issues that impact persons of disabilities and be an active voice in the public square. Third, I would advocate for training for members of the clergy, both initially while studying for ministry, but then also ongoing, with respect to various types of disabilities, best practices, so that they are well equipped to accommodate all members of their community. Fourth, I would say religious communities should be dedicated to creating a culture of belonging to ensure that faith communities are communities of full belonging and not just inclusivity. And some of my reasons for believing that is inclusivity almost seems to imply we are the group who have decided to include you in our number. Belonging says you are part of the group. And so, to the extent possible, religious communities should look not only to how they might serve persons with disabilities, but ensure that there are meaningful opportunities for persons with disabilities to be of service. Faith communities should be at the forefront of seeking, as employees and as leaders, persons with disabilities, seek active engagement and not passive membership, and support a range of social activities that fully involve persons in many different situations. Fifth, there should be increased attention to appropriate catechesis and opportunity for education in faith. And although this is legally required for secular education, it is morally obligated for religious institutions, I believe, to ensure that access to catechesis and the opportunity to learn the faith is fully available. Sixth, practical accessibility in a physical sense. It is important to include things that seem to be simple, like ramps, elevators, restrooms, sign language and amplification, large print and braille, and multiple seating options. In many houses of worship, you may find a dedicated seating area in the very front or in the very back of the room, but having multiple opportunities available in these practical, accessible ways. And then finally, number 7, active outreach. So not just making the place of worship accessible to people once they arrive, but how to reach out to those who perhaps might not be at the house of worship because that house of worship and that faith community didn't reach out. And so this might include, in particular ways, ministry to parents of infants or children with disabilities, continued need and outreach to members of the community after a disability arises, welcome communities that make sure that they ask new members of that faith community how they might be of service, caregiver support, spouse and child support, and I think often overlooked sibling support as well, so that those who seek a home in a spiritual community can find a welcome there, no matter who they are, what they're seeking, because I think the law has some significant gaps when it comes to protecting the rights of religion, and I would hope that faith communities of all types fill in that gap so that law ultimately will be more responsive. And I look forward to conversation later on. Thank you.
Thank you. Mr. Sugarman?
Hi. Thank you, everyone. I'm honored to be here, and I'm honored to be on this fantastic panel. I love to speak about disability, the law, being a lawyer. I'm going to talk about navigating a career in big law with a disability, what that means, and what that looks like. I'm going to start with my background and my disability and what inspired me to pursue a career in law. And then I will talk about the process of getting there, where I am today, what it is like being a big law lawyer with a disability. I will also talk about the unique challenges and opportunities that big law has for an attorney with a disability. For context, I'm a 2021 graduate of Vanderbilt University Law School. I'm a fifth-year litigation associate at Gibson, Dunn, and Crutcher in their New York office. My practice spans all aspects of commercial disputes and litigation, from contracts to Delaware and mergers and acquisitions. I also have a very active pro bono practice in New York state courts and in New York federal courts. Currently, I'm litigating a very contentious Fair Housing Act reasonable accommodation case in the Southern District of New York. Big law has provided me with opportunities that I would not have had otherwise, and provides me with a career in which I can support myself and my family. It also gives me the opportunity to practice law at the highest level, and is a constant intellectual challenge that reminds me of law school, and I loved law school. I grew up in Pacific Palisades, California with my parents, Barry and Laney, and my older sister, Lila. When I was 6 years old, I was diagnosed with Ewing sarcoma, a very rare bone cancer. I had multiple rounds of chemotherapy, I had a knee replacement surgery, and have been in remission since 2001. From that point onward, I had numerous surgeries and other revisions to that knee replacement, and medical issues that oftentimes made it challenging to keep up with schoolwork and to keep up with friends. The knee replacement became infected while I was in college and required an amputation. Despite these challenges, I still had my eyes set on becoming a lawyer. My interest in law began when I was transitioning back to elementary school, following the completion of my cancer treatments. There were certain accommodations that I needed in order to transition into school full-time. I needed certain teachers who we knew could assist in that, implementing those accommodations, as well as other additional accommodations to make that transition the best that it could be. And as part of that, there was an agreement in my IEP with the school district that was meant to facilitate that transition. And they didn't hold up their end of the bargain. And very luckily, a family friend of ours, who's primarily a personal injury attorney, who has always the most interesting cases, agreed to help. And my parents, with his representation, litigated against the Los Angeles Unified School District, and they won and obtained a very favorable settlement. From that point forward, I was set on being interested in the law and becoming a lawyer. And I was so interested in how the law gets things done. It is a system that structures our society, but it also resolves disputes and solves problems. And it's the lawyers who are the ones who solve the problems, and they are the advocates in those disputes. And this is a vision of the law that I continue to work and live by, even if the law does not always live up to its end of the bargain. I've come to learn as I practice, the law does not always get things done. It can take a very long time. It is not perfect, but it is good. And I've strived to become a part of that system from that very point in time. And it was my North Star throughout elementary school, middle school, high school, college, law school, into my legal career. There were many times when I had to miss school, miss opportunities with friends, but I always continued on knowing that in the end, I would become a lawyer. It would take a very long time, but here I am. As I've become a practicing litigator, it has challenged me. My nature, I'm fairly easygoing, and in my law practice, I often have to do the opposite. 9-year-old Alon did not know what a meet and confer with opposing counsel is. And for those of you without the pleasure of experiencing that, it's where you have to sit down with the opposing party as part of litigation in an attempt to resolve sort of minor disputes during the process of litigation without going to the court. And it can often be a very painful process. And you have to say no, and you have to push, and you have to advocate in a way that I think at times outside of that context, our society values being agreeable or accommodating in a way that when you're in that role as an advocate, your job is to stand firm. I think it says a lot about how I chose this career path out of passion, but also one that I knew would push me to develop and fight on behalf of my clients. I know quite a few of you are in law school now, and I'd like to talk a little bit about my law school process, the law school process, admissions, accommodations, recruiting. If you have a disability and are in law school, it is very important to ask for accommodations. In undergrad, I was at a large public school. I had to push very hard for accommodations, not because the school was not willing to provide them, but because it was sometimes very easy to fall through the cracks. And it's an unfortunate burden of the person with a disability to have to push for that, but it's very important to do that and prevent falling through the cracks, especially in law school. In law school, the intensity is higher, the stakes are higher, it is more structured. For me, I found that structure to be helpful. It was easier for me to identify the accommodations that I needed and advocating for them. And I know everyone is different in what they need and how they go about requesting it, but don't be afraid to reach out to your school, to brainstorm with them, to advocate what you need. And I think this goes to beyond law school as well when you are in the working world. Something that's been spoken about on a number of the panels today, self-disclosure. Self-disclosures of disability is something that comes up frequently when I speak to law students, when I speak to practicing attorneys and others in their careers. I've spoken about it on a number of panels at recruiting events. It's something I've debated with other lawyers, with other non-lawyers. I have the classic lawyer's answer, which is that it depends. But I always have a follow-up question to that is, it depends on what? And in my experience, it depends on your personal circumstance and the context. I don't have a choice when I'm sitting for an interview that's in person whether I do or don't disclose that I have a physical disability. If I'm over a video conference, I may have that choice. And as I've talked about, my disability is a core part of my inspiration for pursuing a career in law. And so I oftentimes would choose to disclose even if I didn't have to, because to me it is my basis for why I'm sitting in the interview or speaking with someone about the law, and it's what brought me there. And I've always embraced that story and I haven't shied away from it. And it's a question that when I'm now in the position of doing interviews, that I love to ask the question of why a person went to law school, why they're interested in the law. I think it tells a lot about what their experiences are, what their vision is for becoming a lawyer, how they would fit into the teams that I build and the kinds of cases that I litigate. And I've also found for myself that my disability does not always come up unless I'm facing a barrier. A lot of what I do is on the computer or over the phone, and a good example of this is I was going to lunch with some colleagues a little while back, and in our building in Midtown, there was an area where you either had to take the stairs or you could take the elevator, but the elevator is essentially like outside and across the building and like, down a tiny hallway and, takes, 15-minute walk to get to this elevator. And it's something that I think other people I've talked to have experienced, which is like, what do you do? And your colleagues are sort of standing there trying to be helpful, but not really understanding the whole picture of like, yes, it's hard for me to go up and down the stairs, but I think in this moment, it might be easier for me to go down the stairs here than it is to try to like find this elusive elevator that like, if you've ever been to the MetLife building, is like, no one knows where it is, even the security guards. And so it's in those kind of moments where it comes up and I have to be creative and adapt and be flexible. Another example, and I think this is something that I've come to learn as I've practiced and become more senior, where there are more opportunities in the courtroom and in other places where I made the mistake of not arranging ahead of time how I would transport binders of documents to the courthouse. And I was in this position of, the binders needed to get to the courthouse for oral argument. I was the second chair with a partner. And so there I was with a grocery bag with 2 8-inch binders in it, hobbling out of my Uber, rushing to the New York Supreme Court building on Center Street. And it's those sorts of experiences where I've learned what it is I need to do to adapt and think ahead. Turning to law practice and law firms themselves, if you're in law school, keep an eye out for law firms that have disability affinity groups. I helped found one at my law firm. It's a very good indicator of how the law firm is thinking about and putting resources towards issues around disability. And I've found that you shouldn't be afraid to embrace having a disability and use it to your advantage. I'm very recognizable as a result, and in a large law firm, it's good to be recognizable because people associate your good work with this recognizable person, and more opportunities come your way as a result. And because of that, I've been able to speak with law students, practicing lawyers all over the country about my experiences, provide guidance, and talk through challenges. And I'd like to talk about the day-to-day of being a disabled big law lawyer. And in many ways, as I've said, it doesn't really impact it until it does. But I'd say I'm very lucky. I'm at a firm that's very flexible in the way that it works. It treats lawyers as individual professionals and practitioners, meaning if I'm practicing at the level that is expected of me, and I am showing up to the things that I need to and producing the work product that is expected, my colleagues don't care whether I'm doing that from my home office or from my hoteling flexible office in New York City. Very rarely do I have in-person meetings. I'm now getting to the point where I am scheduling those meetings, and I make an effort to have a remote option for those meetings because it's very difficult for me to navigate New York City. I live outside of the city. It is a very difficult place to get around and is not realistic for me to navigate on a regular basis. And it's important to look for a firm that that offers that flexibility if you're in the process of looking at law firms. And disability is a unique diversity. It can impact how you do your job and what you can do, but I think something I really like, especially having a mobility disability with the legal practice, is if it's not impacting your ability to be at your computer and provide your work product, it really doesn't affect my day-to-day. But where it does come up is in having, I feel like I paint this rosy picture. It comes up more in terms of how I manage my time. And so I will probably have more doctor's appointments than some of my other colleagues. And at a traditional firm, you have a billable hours expectation. And it means that if I have doctor's appointments, or if I have a medical issue that I'm having to deal with, I have to make up that time somewhere else. And for me, I have very high expectations of myself, higher than the firm sets for me. And so I have to think about and work through, if I have multiple doctor's appointments in a month, the next month I might have to work longer and later to make up for that in a way that others of my colleagues may not have to do. And there's disability isn't talked about a lot in big law, and I think there's a lot of fear and confusion, and I try to take it upon myself to a degree to educate, but there's no way to sugarcoat it. The hours are very long, and it is very stressful, but they can be long and stressful in any number of careers, and I really enjoy the work that I get to do. And you have to be a master of yourself and your abilities and your limits, and make decisions about how you structure your time. And it can make being a disabled big law lawyer lonely at times, and I think it was one of the reasons I wanted to start a disability affinity group at my firm. And I haven't met very many big law attorneys who use crutches or a wheelchair, but I've started to meet more and more of them, and it is always a really amazing experience. And that's why I'm so thankful for opportunities like these, where I get to meet and network with others and mentor the next generation of disabled lawyers. And big law has been a very positive choice for me. I think it's not been without challenges. My wife sees on a regular basis the difficulty and time and stress, but also how fulfilling it is for me. And there are many different paths you can take with a law degree, and I'm really happy to connect with any of you individually to discuss your experience, my experience, and provide any guidance or insight that I can. Thank you.
Thank you so much to all our panelists for helping us think more deeply about how disability reshapes concepts of justice, rights, and belonging. I particularly appreciated Ms. Bailey's comments on her experiences of exclusion and building your own bridge, and how that can, you can create a place for yourself in the world. And for Mr. Sugarman for talking about the importance of advocating for yourself, for being adaptable, and for thinking ahead, and how there is a place for everyone at big law. And for Professor Silecchia for talking to us about the very real difference between inclusion and belonging, and the importance of securing freedom of religion for everyone in an explicit and clear way. So thank you all for those wonderful comments. And I'm going to open the floor for questions and answers. But before I do, I wanted to read the end code for the CLE, for those of you who are seeking CLE credit. The code is KNL 953. So KNL 953. Do we have any questions for our panelists? Yes, thank you.
Yes, good afternoon. This question is directed at excuse me, Mr. Sugarman. My partner and I here, our other hat that we have besides our regular jobs is being ADA compliance officers right next door with the New York State Unified Court System. And my question to you specifically is, what challenges have you found within the state court systems as far as any type of accommodations that you have requested? And is there someone in the court where you go that you know you can reach out to, like an ADA liaison, a compliance officer, for your requests?
And I must say my experience in New York State Court with accessibility has been very good. I have not connected with any individual like that yet. I think I'm just starting to get to the point in my career where I am having more opportunities to go to those in-person hearings and trials. And I've found, though, that in comparison to many other courts around the country, the New York State court system is far and above, given their adaptation with technology, much more accessible to attorneys like myself, especially given that for many of the justices aren't requiring an in-person appearance for a scheduling conference that would involve me taking a subway and a car and other things. And I think so far I have not needed to request a specific accommodation of the court yet. But I think when the time comes, I think I will, have to work with our teams and myself to explore that further. And I do know my experience is that the chambers of our justices are very responsive, and I know when there are issues that come up, they oftentimes, or others within our firm, know the person who needs to be contacted for that.
Great, that's wonderful. That's really nice to hear.
Other questions? Yes. I think there's a mic coming down, if you can wait just a minute. Thank you.
All right, so I guess this is a question directed to Mr. Sugarman and Ms. Bailey. My question is, when both of you were in law school, was there a disability law students association at your schools? And like a follow-up question to that is, if there was it helpful for you?
There wasn't any when I was in school. They did develop one after I graduated, though. So there is progress being made there, but when I was in school, it wasn't there.
So there was one when I started, but it was very small. I also was at a very small law school. My understanding is that it is more active now, and I think had it been more active when I was there, I think part of it was that there just weren't that many law students with disabilities, and so it can be hard to have a student group around disability where it's 1 or 2 students with a disability and 10 allies, which I think having allies is extremely important, but it can be very difficult to have a student group that really is fulfilling in the way that you'd want a student group to be when it's that small. But I have mentees at various law schools that have very active disabled law students associations, and I think it's extremely important. And I've been invited to some of them to speak on career panels and recruiting, and I think it's a really, really fantastic opportunity. And to, if it's of interest to you, or if your law school does not have that group, to do what you can to promote it, because it's something that, as someone who now does recruiting, I look for things like that, especially if you're at a school that does not have a Disabled Law Students Association, or if they do and you're active in it, it says a lot to me about your grit and determination, and that's something that I look for when I'm interviewing candidates, and it's a very important way of finding community.
Thank you so much.
Other questions from the audience?
I have one, sorry. I was going to ask how you would say, and this goes to all the panelists, your experiences and your practices have shed light on that, I would say, archaic kind of stereotype Ms. Bailey mentioned at the beginning of your presentation of what a lawyer looks like. And yeah, your thoughts on that.
So, yes, so it is still very much prevalent, maybe not as much as it was, in the past, but there is still a very big stereotype. The company is very diverse, but I am still the only disabled attorney there, which shows that it is very slow to change and very slow to progress, which makes sense. The law is built on precedents, and I think that's one of our historical foundings that we have, which is very unfortunate, but I do think it is slowly starting to change and slowly starting to get a little bit better. Does that answer your question?
It does, thank you.
I guess from my perspective, I have noticed legal education changing a lot in the last 10 to 15 years. And I'm very fortunate to teach at a very small law school, but some of the things that I've noticed just that are different, my classes are pretty much evenly split between men and women. We have a lot of students coming who are parents. We have students who are coming at night trying to juggle jobs. And they want something that's not the competitive, cutthroat, one exam at the end and you are your grades, but we have exams along the way where we can really talk about how students are progressing. I think all of my colleagues are spending more time figuring out how students learn in many different ways. And I think for us, and there was much that was bad about certainly the COVID years, but one bright kind of silver lining, I guess, is it made us all really think about law school from the bottom up once we had to teach in such radically different ways. And when we came back, we really thought about, is the way we're teaching the only way to teach? So I think the profession changes in many ways slowly, but part of that is I think legal education is changing. And when I see it in my students, I see it in the things they want to talk to me about, but it's not just, I teach first-year property students, and they don't just want to talk to me about property. Nobody wants to talk about future interests with anybody ever, but they want to talk about what kinds of careers will balance out with family life? How will I meet my other commitments? What did you like and not like about big firm practice? I'm not somebody who's outgoing and has the Perry Mason personality. What can I do and where is the place for me in law school? So I think the more students are willing to talk about that, I think, I see great things ahead for the profession, but it moves slowly.
I would very much agree. It does move slowly. I do think there has been, at least in the last, I would say 2 to 3 years, quite a big shift, especially in terms of, at my firm in particular, seeing the change in the emphasis on recruiting and finding law students that don't just fit this mold of they went to an Ivy League undergrad and they went to an Ivy League law school and they did, they had X grades, but thinking more holistically about individuals' experiences. And I think my firm in particular is very much focused on self-starters. And so we didn't have a disability affinity group, but now that we do, I think there's more visibility, more understanding, and I think in time, I think the kind of look and feel of what a big law attorney will shift. I'm hoping that as I become more senior, I can, be a part of that.
I believe we have one more question from one of our online participants.
Okay, so this question is, have they yet made an accessible bathroom in Supreme New York 60 Center? Access to 80 Center is terrible.
I'm sorry, okay. Do you want to say more?
So hello, my name is Ben Tapa. I work for the New York State Chief Disability Office. So if you have an issue with the courtroom accessibility, come talk to me. I will relay you to the appropriate person in the court system.
And could you say your name one more time for everyone, once again?
So BENTHAPA. My organization is the New York State Chief Disability Office. We work for the governor of the state, and the website, just search enough keywords, you'll get there, or come to me at this event.
Perfect. Thank you so much. And that's our last question. Thanks again to the panelists. Great conversation.